Bula Vinaka, and welcome to this week's segment of Speak Your Mind. I trust you're all enjoying your week so far. Well, with us this morning in studio, now they're representatives from the Fiji Public Trustees Board. Okay, we've got the CEO and also the acting manager estates. Now, something my dad's always going on about is having to make a will. Okay, make a will. He feels like he's getting older, and I'm sure some of you may think of this, and also thinking about getting a will done. Now, this is where the Fiji Public Trustees Board, amongst some of the other services that they provide. And in studio with us to tell us a little bit more about this is, of course, the CEO, Mr. Atonia Takala, and also the Mr. Camille, who's the acting manager estates. Bula Vinaka, gentlemen, and welcome on the show. And thank you so much for joining us.
Bula Vinaka.
Okay. Yeah. Feeling a bit shy there, Mr. Takala. But yes, once again, tell us all about the Fiji Public Trustees Board.
Thank you. The Fiji Public Trustee Corporation Limited is a private organization owned by the government.
Mm-hmm.
It's a government commercial company that was incorporated in 2006.
Okay.
And the corporation has now been in operation as a company from 2006 since to date. The Fiji Public Trustee Corporation Limited provides services to the people of Fiji,
right,
especially in deceased estate administration services, trustee administration services, preparation of will,
mm-hmm.
something that it's a hot cake right now in the market, and everyone is everlasting talking about wills. The Fiji Public Trustee does provide that at a very reasonable cost to the people. And there are other legal services that we can assist people on, and we have our office here in Suva and one in Lautoka, and we also work very closely with the public, with the DO's office throughout Fiji, in trying to ensure that we deliver our services to the people of Fiji. And the Fiji Public Trustee is here to also serve the people of Fiji as a whole.
Okay. Mr. Camille, you're from the acting manager estates. Tell us a little bit more about your role in the company.
Thank you. With Public Trustee, we deal with deceased estates, assisting clients and beneficiaries in taking out probate from the court,
mm-hmm.
and passing inheritance to the surviving beneficiaries.
Okay.
The process of estate administration, it's a bit of a lengthy process where if someone has passed on with a will and he has appointed public trustee as the trustee, we come in on behalf of the beneficiaries to take out probate from the court and then transfer the estate to the surviving beneficiaries. The other one is where somebody passes on without a will.
Okay.
Yeah. And the next of kin is unable to administer the estate. The next of kin can also come through public trustee for this administration process. It's a similar process where we go through court to take out probate and thereafter distribute the estate.
Okay. Mr. Camille, if you don't mind, if I can get you to just talk a little bit more closer to the mic, so it's a bit more audible.
Sorry.
That's okay. All right. For the power of attorney, I believe this is one of the services that you also provide.
That's correct.
Tell us a little bit more about that, Mr. Takala.
Yeah, the power of attorney is a service that we provide to those who appoint us to take care of a personal property,
mm-hmm.
or in some cases even for personal care or welfare. This has happened in a few cases whereby a particular person is no longer able to manage his or her own affairs,
right?
Especially financial affairs, in looking after their own things. Then they can appoint an attorney to do that on their behalf.
Okay.
Or if there's someone overseas, they want someone to look after their property while here, or manage the property while here in Fiji. That's where you appoint a attorney to also assist you in managing your affairs, in looking after the property in Fiji.
Mm.
And the Fiji Public Trustee does provide that for those. We also prepare the documents, just preparing documents for those who want us to prepare a document of power of attorney, appointing someone else or appointing the Fiji Public Trustee. We also provide both of those two services.
Okay. Now, I remember asking you this when we had a discussion earlier. Now, overall, I know you can't really put a figure in it, but percentage-wise, do you think a lot of the public, a lot of people are aware of the Fiji Public Trustees company services?
Yes. Overall, I think quite a good number of people are aware. We used to be just known as the Public Trustee Office.
Mm.
that used to operate under the Ministry of Justice.
Okay.
But since 2006, we then became corporatized into the Fiji Public Trustee Corporation Limited, where we now operate like in a company to improve the services that we provide to the people and become more accountable to the assets that we look after that are in our custody, both financial assets and real assets, like in real estates. And that is one of the main reasons, in making it more independent organization to operate and be transparent, be accountable to the services that it provides to the people of Fiji. And the Fiji Public Trustee Corporation Limited is scrutinized in every way, is open to scrutiny. We get our accounts audited every year by the Auditor General's Office.
Right.
We have to meet up to the international accounting standards in preparing our accounts, and all that is carried out within the company, which was not there when it was part of government.
Yeah.
So now it has been independent, and also one of the main reasons is try to improve the service that we provide to the people.
Okay.
More efficient service, timely services, especially now when you deal with estate administration, it's a lengthy process.
Of course.
So that's something that the corporation now is mostly focusing on, is trying to continuously improve the way that we provide this service and looking at ways in which we can quickly or efficiently manage and distribute an asset on a timely basis at a very low cost.
Now, you mentioned that the services are quite free, and also before a lot of people, would you say before a lot of people used the Fiji Public Trustees company, or a lot of them now actually go to solicitors or other services?
Yeah, this particular service is also provided by solicitors throughout Fiji. They provide a similar service. We provide it at a much more reasonable cost to the people, and that is a reason why we existed in that. And also we exist also is through appointment of court, where the court appoints someone independent. Usually it chooses the Fiji Public Trustee,
right?
In especially in management of estate cases.
Now, remember, I asked you guys this: what is the difference between the services provided by the solicitor and also the Fiji Public Trustee Company?
Yes, the solicitors have a wide range of legal services that they provide to the people. The Fiji Public Trustee simply works within the act that governs us, the Fiji Public Trustee Corporation Act, and in that it simply limits us to providing estate administration services, trustee services, will preparation, and other legal services that we can provide, which is within our act.
Yeah.
So that's simply the major difference, and the other major difference is the cost effect.
Okay.
The cost of the lawyers and the
which is very important.
Yes.
Okay. Well, we'll talk a little bit more about this and also the differences. And if you have questions for our in-studio guests, feel free to call us up. That is on 3220-906 or 907, or you can even text us on 825. Don't go anywhere. We've got more Speak Your Mind to come on Gold FM. Welcome back to Speak Your Mind. And if you just joined us, we're talking to the Fiji Public Trustee Corporation Limited CEO, Mr. Tonia Takala, and also their acting manager estate, Mr. A. Camille. Now, Mr. Camille, you deal with the administration of deceased estates. What are some of the common cases that you have to deal with while you're at the Fiji Public Trustee Company?
Thank you. With deceased estate, the common ones where beneficiaries or next of kin come in, beneficiaries of deceased estate that die without a will. This is one of the common one that we normally deal with. We do have cases where deceased has passed on, leaving a will and appointing someone as an executor or trustee, and we come in to assist the next of kin or the beneficiaries with those cases as well.
What are some of the steps that you have to undertake to deal with these cases?
Okay, we normally interview the beneficiaries or the clients or the next of kin and advise them of the procedures for taking out probate. to administer any deceased estate, whether with a will or without a will. And the step that follow from there, the process that are involved, applying to the court for probate, and then once the probate is granted, the assets that has to be administered, if there is a property, how the deceased had wished that the property to be distributed, if he had a will, and so on. We also assist those beneficiaries. If it's a leasehold property, we apply for consent before transferring the estate, attending to stamping of documents with the Stamp Duties Office, and thereafter registration with titles. Those are some of the processes that we...
So you guys actually work really closely with the company lawyer on this?
Yes, we do, yeah.
And are there some instances where the clients come with their own personal, their family lawyers, or do they actually just follow with the lawyers that the company provides?
Well, in most cases, it's just our in-house solicitor.
Okay.
And unless if there's a dispute or something amongst the beneficiaries, and one beneficiary is presented by his or her lawyer, then that's where we will
assist them.
That's right. Yeah.
And the whole process is done or is assisted by the Fiji Public Trustees.
That's right. Yes.
Corporation.
With us, we do the whole process of taking out probate and distributing the assets. With the lawyers, in some cases, they go as far as taking out the probates on behalf of the next of kin or the beneficiary, and then the beneficiaries are left to do the transfer and so on. We've had cases where these beneficiaries have sought assistance from our office, and we've assisted them. In applying for transfers and so on.
Exactly.
Yeah.
In some cases, what are the cases where there is no a lawyer involved? Excuse me, not no lawyer involved. When there's no will, though. When there's a will not done, and then you have to administer their estates. How does that come about?
Okay, what happens is the next of kin they come in and advise us, inform us of this and seek assistance from us. And the next of kin is required to authorize public trustee under our act in order for us to apply for probate with the court. We take them through the process, and we give them the option. The options that are available is they can go through us, or if they know of a solicitor who could assist, then they could engage the solicitor. But if they go through us, like I said, they'll have to authorize us under our act. And based on that authority, we apply to the court for a grant of probate.
All right. Okay, I believe we have a caller on the line. Bula Vinaka, how can I help you?
Good afternoon.
Good afternoon. Who am I speaking with?
Are you speaking with Vanna?
How are you, Vanna?
Not too bad, my dear.
Okay, I believe you have a question for our studio guests.
Yes. I'm just inquiring. I was one of those that went through the public trustee.
Okay.
Because my father's estate didn't have any money.
All right.
And we actually gave them the authority to act on our behalf.
Okay.
So what happened here, after they had finished with us, I got a letter to come and pick up the title. So I took the title away, and then I was trying to distribute the land to all the beneficiaries, as a trustee.
Exactly.
But then I had problem with not even a beneficiary. She took the title and took land out. I want to know if that's allowed. She took the title because of her husband being a trustee, and he had died.
Okay.
So she took my title away, and she actually took land out, and she took it out on paper, not actually getting a surveyor to do it, without consulting me or any of the other proper beneficiaries.
Okay, I believe, Mr. Camille, this will be a question for you.
Thank you, Vanna. Is the property a leasehold or freehold property?
It's freehold property.
Freehold. And how many beneficiaries?
There was 9 beneficiaries, 9 girls and 1 brother.
Okay, and you said that you had gone through public trustee.
Yes, we did. We had to go through you because apparently we didn't have any money in the estate.
Okay.
And when you were finished with us, you actually called me to come and pick up the title. We had to pay you a fee, of course.
Okay. And did we transfer to all the 9 beneficiaries, or?
Yes, it was all transferred. But what I'm saying here, she was not a beneficiary, but she actually took the title and took land out.
She was married to a trustee.
She was married to a trustee, and we all haven't got our titles yet. I'm working on it slowly. As we get money, I'm trying to get the surveyors in and, give everybody what The will says, my father's will, eh?
Okay, so I believe this is something that you mentioned about the spouse or the, is this one of the incidents?
Yeah. One of the beneficiaries that had passed on, the spouse has taken over. In other words, the spouse may have applied for probate or something from the court to be the legal representative of that estate. Probably that's the reason why. But
she didn't consult me, or she didn't consult any other beneficiary. As a matter of fact, I'm working on it. Okay. I haven't been sitting on it. Okay. When the money comes in, I actually do a little bit as I go along, you know.
Okay. But for your information, she's only entitled to that portion of the land, which is the 1/9 share of.
That's right, exactly.
Yeah.
But so your question is she allowed to do this?
What right does she have to touch a document that she knows there's the two trustees in charge, and she goes over her head and touches the document?
Well, I think in that case that'll be between you and this lady. Now, because what has happened is we have finalized that estate and we have transferred to the 9 beneficiaries. So if she were to come in, the 8 beneficiaries would have given consent or something, that for the release of title or something.
So does Vanna can Vanna contest this and say that we haven't given
yes
we haven't given consent, but she's able to take this, so she will have to go through.
She can go through court in this case.
What I'm thinking of doing, because I don't think she should have done that. I mean, a different thing if I was just sitting on it and doing nothing about
maybe
it.
what you can do, Vanna, is you can refer this to court, and then let the court decide from there.
Yeah, because really no one's taking anything away from her.
You just wanted to follow the process.
She has, after the girls get their share, she gets the rest with the house.
Okay.
You know? I'm not debating that.
Okay. Well, thank you, Vanna. I guess it all comes down to just following procedure.
Thank you very much.
Vinaka, you have a great day.
Thank you.
Thank you. Bye-bye. Well, we've got more still to come on Speak Your Mind. And once again, if you have questions for our in-studio guests, feel free to call us up 3220-906 or 907 or text us on 825. Stay with us. More on Gold FM. Welcome back to Speak Your Mind. And yes, in studio with us once again, the CEO, Mr. Antonio Atonia Takala, the Fiji Public Trustee Company Limited CEO, and also Mr. A. Camille, who's the acting manager estates. Now, before we went into a break, we all had a caller from Vanna who had actually inquired about a process or a procedure that she needed clarified on. Now, we're talking on wills and also administration of estates and also services provided by the Fiji Public Trustees Company Limited. Now, we're coming out of a break, but we've also got a caller, Lillian, who's online, and she'd like to ask our guests a question. Lillian Bulavinaka, what is your question for the guests this afternoon?
Lisa Bulavinaka. My question is, 3 brothers.
Okay.
Yeah. When their father died, he left his share of the land to them.
Mm-hmm.
Okay, these 3 brothers, they don't, actually, my father was the eldest.
Right.
He's got 3 daughters. 3 daughters, and grandfather's will said when he died, he left it to the 3 sons. So my father dies.
Mm-hmm.
Before he died, he divorced my mother and married again.
Okay.
But he's got only 3 biological daughters.
Right.
Okay. Second brother says just because he divorced my mother, that we are not entitled to his share of the land.
Okay. So your question is, are you entitled to the land according to the will?
Yes, because he did not leave a will, but before he died, he told me that what's his belongs to us, the 3 daughters.
Okay, this is from your father, who is one of the 3 brothers.
Yes.
Okay, but it was a grandfather that stated that the will goes to the 3 daughters or the 3 sons.
The 3 sons.
Okay. That's a scenario for you, Mr. Camille. What would you suggest?
Thank you. How many siblings altogether? You and this is 6 of you, eh?
No, 3.
3, eh?
They're the 3 daughters of one of the brothers.
One of the brothers.
Right. Their father did not leave a will. Their grandfather did to the 3 brothers, who is one is her dad. He passed away, but he remarried after he divorced his wife, and they're the biological daughters of the father. He never married again. But then, according to the other two brothers, the children are not entitled.
Just one brother.
One brother.
Yeah.
Okay. The kids, the children are not entitled to his land.
Because he divorced my mother.
Okay. What do you think about that scenario?
Okay. So, sorry. Okay. So your father is survived by 3 daughters and one brother. Is that correct?
No. The father has 3 daughters, but he has 2 brothers. The 3 brothers were entitled to their father's land. She is the daughter of one of the 3 brothers that has passed. Do you get it now?
And your father did not leave a will.
Did not leave a will.
Okay, but he divorced before he
passed
on.
Yeah.
So
she's asking, are they entitled to any of his if he's of his land?
Yes, they will be entitled.
He will be entitled. Yeah. As a sibling of the beneficiary,
yeah? Yeah. Okay, so Lily, have we answered your question? You are entitled to the land.
To our father's share.
Yes, as a beneficiary. Your father as a beneficiary. One third share.
Oh, 1/3 share.
Yeah.
Okay. Yeah. Thank you so much.
Thank you, Lily. You have a great day.
You have a good day.
Linaka. Well, like we've been mentioning, the importance of having a will.
Yes. That's true.
What weight does having a will carry as opposed to those that don't?
Yeah, I think the will is where you state your final wishes.
Right.
And it's a legal document, and whoever you've appointed as an administrator or an executor in that will need to carry out that your wishes as stipulated in your will, and that's why the will is very important. Because it highlights your wishes. If you do not have a will and you pass on, then we will have to follow the law, what the law says. Who's the next closest next of kin? Yeah? And that may not be what you wished.
Okay.
You may not want it to go to your brother or to your parents, but you want it to go to
Have you had instances where wills have been done, they've drawn up maybe 5 years ago, and then the situation has changed? Like, for example, someone was married back then, maybe not divorced, but living in a de facto relationship 5 years down the line, did not amend the will, happens to kick the bucket. And then you have instances where the person says, but he's not with the wife. I'm his de facto partner, but I don't get anything. Yeah. What happens when that situation arises?
That's why we always emphasize the importance of having a will. It comes back to that. Circumstances do change. For example, in a case of a divorce, if you're the legal wife, push hard to try and get your husband draw up a will.
Yeah.
And if you're on the other side, the de facto, you also push on the other side to ensure that probably you might want to get a share of that particular person's assets as well. So that's why it's very important to have a will, and in the will it should highlight who you want to appoint as your executor and the distribution of your assets highlighted there, and that covers any assets you want.
Yeah. Mr. Camille, I remember you interestingly said that even though this situation arises, you also have this instance where the de facto also has entitlements?
Yeah, that's correct.
Can you elaborate a little bit more on this? Because this is Fiji, I'm sure. Okay, no secret about it, but we live in situations where this certainly arises.
Yeah, in fact, the de facto spouses, they almost have the same entitlement and privileges as the legal spouse.
Right.
So it's always good that you change your will as the circumstances changes, like Mr. Takala had mentioned. If somebody is going into a de facto relationship, you should always go back and change your will. So it's a more clear line of distribution of your assets.
And if any of them should take legal action against each other, there's always the court that decides at the end of the day.
Court,
Okay, well, there you have it. So just for your information. We'll have more still to come on Speak Your Mind. If you just joined us, welcome on the show. If you have more questions for us, feel free to call us up 3220-906 or 907. We're heading into a break, but we'll be back with more. Welcome back to Speak Your Mind. Now, once again, if you just joined us, you're on Gold FM. This is live on radio and also recorded for your viewing pleasure on FBC TV. It's Tuesday nights at 10:30. Now, in studio with us, we have the Fiji Public Trustee Corporation Limited's CEO, Mr. Atonya Takala, and also Mr. A. Kamil, who's the acting manager estate of the company. Well, we've got another question for you. Gentlemen, our line's been ringing like hotcakes, so it's really good that you're here. But yes, my friend, who do I have with me on the line? Bulavinaka.
Reg, yeah.
Reg, okay.
The
Go ahead with your question.
Here that a man made a will. It was all going well, and then another will was made. But in the meantime, the man had suffered dementia, old age, Alzheimer's kind of thing. Right. Now, the second will was made during that period, and I was wondering if the gentleman can explain, with the people mentally not capable, whether a will can be changed. Thank you.
Okay, well, there you have it. Reg there with his question. Will process making towards the second will, he suffered dementia or basic amnesia.
Yes, that's a very important case scenario, and one that has created a lot of interest also in our office.
Right.
Especially the state of mind in which that person was in.
Yeah.
I think the law or the circumstances that surrounds that, it should be at the person with proper sound mind.
Sound mind, yeah.
Yes, sound mind. And if the person was not in a state of mind, then it could be challenged.
Right.
After his death, and then the court will then have to decide at the end.
Yeah.
In those cases.
Is this one of the policy or one of the rules when making will for the will services? Is this one of the criteria that needs to be in place?
Yes, for us at the moment internally we have our internal procedures now, in which we are when making will, we have to ensure that the person is with his right state of mind.
Right.
In certain cases where we go to hospitals or to their homes, we would prefer to have it with a doctor present or a police officer, somehow testing.
I think for my friend Reggie here, he said it was in the process of making a will. So he started off of sound mind, and then towards the his probably mental state started to, he started suffering dementia in the process. What then with that scenario? What happens then? Because he entered off sound mind, would the will still be valid?
Then it probably comes down to the time he signed it.
Okay.
At the point where he signed, and then it would become, if there's someone else who knew of that and thinks that the will is questionable, then they can challenge that.
Right.
On those grounds. So it is quite important to ensure that those areas are covered.
Yeah.
That the person should be at his right state of mind, and doing his will willingly.
Right, not being forced,
not being harassed, or under duress, and that he is doing it with all pleasure, and he's doing it for that.
For the will making services, who normally is present when the person does the will? Is it just the lawyer and the applicant, or how does the process work?
Yes, for us, we usually have it just the officer together with the person intending to, or the testator of the will. And we simply, interview him on a one-to-one basis, ensuring that there is no harassment or that he is not doing it under duress or whatnot. We had an instance whereby a man was brought to the office with a wheelchair by the daughter, and then when we interviewed the father, then the father got a shock that he was there. He was not sure what he was there for. He was there for. Then we explained to him. Yeah. And then he said, okay, I'll go back and then I will rethink this over and then come back. So those are very important things. A will is a very important thing. We should not be forced to do it, and it should be done willingly and also legally. Okay. There have to be witnesses when signing off the will.
Does it have to be a family member or someone?
Usually someone independent to sign the will.
Okay. And for example, like I said, you said someone of sound mind. For someone that you look at, like from an employee's perspective, if you look at someone and you think they're not of sound mind coming to do their actual will, do you need to get a doctor's recommendation on that person's mental capacity, or even on that person's how would you, like, for you, your own opinion of someone?
Yeah, that's a pretty difficult to to determine,
right?
Especially because we need a doctor to be there or whatnot. But if he's able to properly outline his wishes and things correctly like any other person, then we would presume that he's of his sound mind.
Right.
And with witnesses signing off his wishes and whatnot in that will, and to ensure that all those areas are covered. One of the other things that we also highlight in wills that's coming now is sometimes some parents exclude one of the sons or the daughters from the will.
Right.
And we always encourage them to try and mention that in the will. Why are they
excluded
them,
exactly.
So probably the elder son is now married, has a job, have a property, and that's why he's been excluded from the will.
Right. So they have to elaborate as well.
Just to cover all those areas.
Okay. All right. Well, I believe we have another caller on the line. Bulavinaka, who am I speaking with?
My dear, it's me again, Venna.
Hey, Venna.
I'm just inquiring about what if the person had made a will and he's in sound mind, and then the will gets changed when he got dementia.
Okay.
Thank you.
Thank you, Venna. A person makes a will when they're of sound mind, but then changes when they have dementia. Like you mentioned, I think this is where they...
it comes back to what I've just said.
Yeah.
Proving that he was of sound mind or unsound mind is going to be the issue in that. But if he signed the will and then the will is produced in court and then someone challenges that, then it will come down to that. What proof there was to say that he was of sound mind or of unsound mind. So it'll come down to that, and it will be before the court in that way.
Okay. Well, then I hope that answered your question. Thank you so much. And what other cases have you had to deal with when it comes to someone that has not written a will, or someone that has written a will but did not elaborate on certain situations like you said? What are some of the cases that you've had to face?
I think for cases mainly, someone coming out of the blue and saying that I am the son of that particular person, and
you have rights to this.
Yes, I have rights to this. This is my birth certificate. You can see that it's mentioned there. He is my father.
Okay.
And what do we do in that kind of case?
Yeah.
And usually it goes back to what's there on the will. If he was not mentioned in the will, then he simply would not be included in that distribution.
And all this is a confidentiality process?
Exactly. It's confidential for those that prepare will. It is confidential, and it's only between you and the officer who prepared the will. And then for us at the Fiji Public Trustee, we then take this will and we register them at the High Court.
Okay.
Where all the wills are registered as well.
All right.
With the Fiji Public Trustee.
Nice. Well, we've got another break coming up. I know this is pretty interesting conversation, especially for those of you who haven't been or who are not aware of the services of the Fiji Public Trustee Corporation Limited. Hey, if you have more questions for us, feel free to call us up 3220-906 or 907, or even text us on 825. Another break coming up, but don't go anywhere. More still to come. Bulavinaka, and welcome back to Speak Your Mind. It's our fifth and final segment of the show, and it's pretty interesting, and I'm sure a lot of you have had your queries answered. Now, speaking of queries, we also have a caller on the line who called up earlier, a bit too shy to go on air. But yes, I believe the question that they asked was, if you're in a de facto relationship, okay, and you have a child, is your child entitled to any of the estates or whatever that they need? Any entitlements? Does a child in a de facto relationship have entitlements? Basically,
yes. If you register that child, then definitely he is your sibling, your son, and or your daughter. Then that child is is entitled to your distribution. But again, comes down to who you state in the will.
Okay.
And if you want to include that child, then you can include that particular person in the will.
So every minute detail.
Yeah. And if that person passes on without a will and he registers that child, then that child has a claim towards that particular person's estate as well.
Okay. Now, fine details. What are some details that a lot of applicants or people actually miss when writing a will?
Yeah, I think a few of the important things when writing a will is the person you are going to appoint to be your executor.
Okay. Now, how important is the executor?
Do you fully trust that person?
Okay.
You know, because he is going to distribute your assets upon your demise. And who knows, that person might pass away first before you. And then, that becomes another issue.
Do you have to have another backup executor?
Yeah, that's why we always highlight it. That's why it's important to appoint someone like the Fiji Public Trustee who will always be around. We may not be there in the next 10 years, but the corporation is still there.
And the
corporation will still carry out your wishes in that. Okay. So that is a very important point. Whom you appoint as your executor, a person that you can trust. And also, you have to also bear in mind that the job of the executor, as highlighted by my colleague, it's a mammoth task. It's cumbersome, it's time-consuming, it involves a lot of office that you'll have to try and go into, and doing transfers and all that. It's not easy, and it's time-consuming, and it's very costly nowadays to go through all that process.
Okay.
And that's why we always encourage people, the Fiji Public Trustee have been doing that for years.
Yeah.
For over 40 years now, we've experienced in that. We have our links with other organizations, government organizations and agencies. And, we are able to quicken that up and carry out in that. Another important thing in mentioning in your will, the distribution, carefully outlining how you're going to distribute your assets, whom you want to go, whom you have allocated, the distribution model that you have followed, in distributing your will and properly executing the will. So those are some of the important things. And another thing I would like to highlight, the will, if you come to the public trustee, we're offering to the public, it's only $20.75.
To write up a will?
To write up a will if you're appointing the Fiji Public Trustee. But if you'd like to appoint someone else as an executor, it's only $30.75.
Okay.
You should not be paying more than that.
So basically what you're saying is if they come and write up a will with you, you become the executor.
Not necessarily.
They can bring in their own executor. They can nominate someone.
They can nominate someone as their own executor.
Okay.
And in that we charge $30.75.
Just a little bit more.
Yeah. But if they're appointing us, then it's only $20.75. And for us, the wills that we prepare, it is kept safely in a fireproof safe, we could say.
Don't tell anyone now.
And then we also register this will with the High Court.
With the High Court.
Yeah, and there's always a copy with the High Court. That's simply, in cases whereby a person passes on and did not tell anyone that he had a will. And then also the public trustee may have not known that he has passed on. Say one of the relatives went ahead and tried to apply for a letter of administration at the High Court would pick it up. Would pick up that there is a will in existence.
So you don't automatically have the authority to go to that person and say, your so-and-so had written up a will and your name was mentioned, so we've come to let you know that this will exist.
Now, only if someone comes to us and informs us that he has passed on,
right?
And then we check through our records, he's got a will and he has appointed us, then we come into the picture. So it happens in that way. But in certain cases, Fiji is quite, separated, and there are people in the north and in the west. Someone has passed on, and then one of the next of kin would like to apply for a probate, for letter of administration.
Right.
That is where the High Court will then pick up that and advise that there is a will in existence. It is with the Fiji Public Trustee.
Have you had instances where that happened?
Yes,
that has happened.
Yes, that has happened a lot. A lot go through solicitors, and then the solicitors were advised. You have to go through public trustee because there's a will in existence.
Right.
And they have appointed the Fiji Public Trustee.
Okay.
Then we come in that picture.
Right.
Yeah. Also, to highlight, importance of having a will because circumstances do change. You might have an additional child. You want to include that. You can always come back to the Fiji Public Trustee and change that will at any time. At $20.75,
So every time they change, it's
every time it changes, and even if you are into a divorce relationship, or if you've bought another building and you'd like to include, this particular child, then you could always come and change that again.
Okay. Now, Mr. Camille, I believe you have had situations where once the will has been read, the person has known, who the entitled or the land goes to. So you also deal with the transaction of that particular land?
That's right, yeah.
Okay, what are the process involved?
That will have to be probated after the demise of the testator or testatrix. And, the next of kin or the beneficiaries comes in with all the documents and all relating to the estate, yeah. Once the probate is granted, if it's a leasehold property, like how I mentioned earlier, we'll need to apply for consent, depending on how the distribution is, whether it goes to the son or to the daughter.
Right.
Yeah. we prepare the documents, the consent, the transfers, and then formally obtain consent, and then the next process is getting it stamped at stamp duties and applying for CGT, which is capital gain tax. It's a requirement now. Any transactions or dealings relating to property, we are required to apply for capital gain tax. For estate cases where we are just passing on inheritance to surviving beneficiaries, there's no capital gains, but we still have to formalize that by applying. And the final process is having the transaction registered at titles office. Once the transfer is registered, and then we formally discharge the title to the beneficiary.
Yeah. I remember I mentioned this earlier as well. I asked you this earlier. Now, for any of the assets, or any of the land or assets that the family have or the applicant has, do they have to show proof that it belongs to them? Every little asset that is listed on the will, or just certain ones?
Yeah, I think that's just mainly for our internal purpose. Yeah. Okay. We usually want them to bring a copy of the title if it's registered under them, and also for us to ensure that we write the full description of the title on the will, so for the details. Otherwise, money in the bank, they can always just mention, money with ANZ or Westpac, shares, or whatever. They have a boat, or they have their furnitures at home, the ring, the jewelry, and everything. They can also mention whatever they own. Into a will.
All right. Well, you know what? It's been interesting talking to you, gentlemen, and I'm sure we'll have you probably back on the show, maybe sometime later this year. But that is it for Speak Your Mind today. Sure hope you enjoyed the program this week. Until next week, you have a fantastic afternoon, and we leave you in good graces. Mother for now.